Hey guys, it's Chad Van Horn here again with another episode of The Debt Life. Today we're going to talk about the top 5 bankruptcy myths that we hear every day from our clients on reasons why they want to avoid filing bankruptcy. The first one is, I don't want to impact my spouse. Now the good news is, by filing bankruptcy, it will not impact your spouse. Now if you have joint debts, it may be advisable for both of you to file, but your spouse does not have to file. And if you only file individually, it will not impact them at all. We don't even need their social security number. Now, in 2005, they amended the code so they look at household income and household expenses, so we would need to get that data. But again, it will not impact your spouse's credit score, or anything like that. So that's our number one myth. Number 2, the court's going to take everything from me and give it to my creditors. Now, the good thing in Florida is there's tons of exemptions to use. The number one exemption that people know is homestead. So if you have a home, generally speaking, it's going to be exempt. They won't take it from you. They won't make you sell it, give it to your creditors, anything like that. Also, there's certain vehicle exemptions where you can keep your car. If you have a leased car, they're not going to take it because it's really not your car anyway. You just have to make monthly payments on it. And if you have a certain amount of equity in it, there are ways to work out payment plans or work something out where you're still going to get a discharge of the majority of your debt and able to keep your car. Obviously, they don't want mementos. They don't want your dog. Nobody's coming after Chuckles, certainly not letting anybody take him. But you do have to list all of your assets, and the bankruptcy system is a fair system where if you are over exemptions, there are ways to work out payment plans. The third, and this might be the most common that I hear, is I'm not going to have access to my credit for 7 years after filing. That simply is not true. Generally speaking, a case will take 3 to 4 months to get your discharge. After you receive your discharge, you can start rebuilding credit immediately. You can reestablish, get a secured card, and build your credit from there. I have a lot of clients that are getting into the 700 credit scores as soon as 12 to 18 months. The FHA says after 24 months, they will back a mortgage for somebody to file for bankruptcy. So you certainly will have access to credit, and it's definitely not a life sentence, a 7-year sentence, or a 10-year sentence where you won't have any access to credit. Another objection is I make too much money to file. There really is no income limit to filing for bankruptcy. Now, there are income limits for certain types of bankruptcy, 7 versus 13, that we've talked about in other podcasts. But everybody is eligible for bankruptcy. You just need to speak to an attorney to see whether it's the best choice for you. And then lastly, it's morally wrong to file bankruptcy. That simply is not the case. It's really a business decision that's for you and your family to rebuild from. The history of bankruptcy actually is derived from the Bible. Every 7 years, you get a fresh start. You forgive the debtors and they forgive you. So it certainly isn't a moral issue. It's more of a business decision that's going to help you grow into the future. Of course, if you have any questions, you can set an appointment with me or call. Thanks for listening to this episode of The Debt Life. Again, the founding partner of Van Horn Law Group, Chad Van Horn. Have a great day.